Welcome to Bridging the Gap, the podcast where we connect families, educators, and advocates to empower neurodiverse children. I'm your host, Kaela Westman, special education advocate and founder of the Bridge Coaching Services. As a passionate advocate and dedicated coach, I've seen firsthand the transformative power of collaboration and support. Together, we'll explore the latest insights, strategies, and stories from the world of special education, all aimed at bridging the gap between families, schools, and communities. Hello, and welcome to Bridging the Gap, where we bring you insights, tools, and resources to help effectively advocate for your child with special needs. I'm your host, Kaela Westman, and I'm so happy to have you join me for our next episode. Today, we are diving into probably what I think of as one of the most important tools in your own advocacy tool belt. We are going to talk about procedural safeguards under the Individuals with Disability Act, or IDEA. If you are raising a neurodiverse kiddo or neurospicy, then you know that navigating this world, this special education system, can be really overwhelming. But understanding your rights and your child's rights under IDEA can make all the difference in the world. So I have been in meetings where the school proposes a placement or a service that maybe just doesn't sound right. It's not the decision we were expecting, or it doesn't align with the needs that the parents see for their child. And that's why the federal government wrote the procedural safeguards under IDEA. They are there to protect you and to protect your child's educational rights. They're a safety net, ensuring that you, as the parent, have a voice in every decision that's made in your child's education. They provide you with tools to challenge decisions, seek mediation if necessary, legal action provisions, all of these scaffolds and supports to ensure that your child receives faith, free and appropriate education that they're entitled to. When one of my clients came to me, they first scheduled their consultation because their child's IEP team at school had held the meeting without them. The school attempted to contact mom and tried to schedule it at a time that didn't work for her. And she told them that it didn't work. And the school took that as this parent not wanting to attend her child's IEP meeting. So they held it without her. This is where it becomes crucial to know your procedural safeguards, because one of the cornerstones of procedural safeguards is parental involvement. In fact, there are some key components to the procedural safeguards, and the first one, the number one provision of your procedural safeguards is the right to participate in all meetings. So as a parent, you have the right to be involved in every single meeting about your child's identification, evaluation, educational placement, and provisions of FAPE. You are an expert in your child. You have insights and observations that are critical to helping to shape your child's educational experience. It's important to remember that you are an equal member of the IEP team. Your voice is essential. One of the other really important pieces of the procedural safeguards is prior written notice. So this is a document that your child's school will send you or show you at a meeting that before any change is put into place for your child's IEP, whether that's identification, placement, a change in service, your school has to give you the prior written notice. And so this document outlines what the school is proposing or refusing and why. It will also have on their form how you can dispute these decisions if you don't agree. But the prior written notice is important because it's going to outline correctly written notice is going to outline the school's thought process. So if you have requested a specific evaluation, let's just say a communication evaluation for social pragmatic language, and your school is refusing this, in in the prior written notice, there's a section that says why the school is refusing to conduct this assessment, to take this action. And so there they must outline the reasons why. So when we look at that, the reasons why they're refusing them, we can identify and see where they are coming from so that we can have a um, comprehensive collaboration and help them understand why we feel it is important that your student have this evaluation. It really is a guide on your school's thought process and really gives you the information to respond. The third component, or one of the components, is consent. So before conducting an initial evaluation, your school must ob- obtain your consent. For reevaluations, your school must provide documentation that they have attempted to obtain your consent. Consent means that you understand and agree to the proposed actions. If you disagree, you have the right to say no, which then stops the process until a meeting can be held or further discussions can be held. Okay. One of the important details here is that you understand. So many times we get into meetings and the team starts spouting off with letters. And unless you live in the educational world of special education, they don't always make sense. So we need to make sure we are asking for help. If um, you are attending a meeting without an advocate or without somebody there with you, you can always write down your questions, write down the acronyms that you hear, and make sure before you consent, you know what everything means. One of the other tools in the tool belt given to you by your procedural safeguards is the independent educational evaluation. And this comes into play if you disagree with the results of the school's evaluation. You have the right to request an independent educational evaluation, or IEE, at the public's expense. What this does is allows you to get a second opinion from a qualified examiner who's third party. So they are not employed by the school district. So that can provide unbiased documentation and information about your child's needs if you feel like they have been inaccurately assessed at school. Another component is the confidentiality information. And basically, this is kind of similar to the medical field FERPA um, or HIPAA. I need more coffee. HIPAA. Under IDEA, the school must keep your child's educational records confidential. This includes, everything from names, addresses, and details about their disability. This also means that staff shouldn't be chatting about your child on the playground. They shouldn't be having coffee at a coffee shop talking specifics about your child. You, as the parent, you have the right to inspect and review all educational records related to your child and request corrections if you find inaccuracies. I have a client that we did a records request and found some inaccuracies in their file regarding actions that had happened the year prior. And we had documentation of those events that were missing from their official school file, and we were able to provide that documentation and have it added back into their file. It's really important to have the whole big picture of your child be accurate. Okay, this file follows them through their educational career, and it's important that everybody is on the same team. The confidentiality is crucial to protecting your child's privacy and making sure that their information is shared only with those who are really directly involved in their education. Another component is the discipline procedures. So when it comes to discipline of a child who is on an IEP, IDEA provides really specific protections for students with disabilities. If your child faces disciplinary action, such as, suspension or expulsion that would result in a change of placement, the school needs to conduct a manifestation determination. This review determines whether their behavior is a manifestation of your child's disability. If it is deemed to be a manifestation of your child's disability, then the school cannot proceed with disciplinary action and instead needs to review and revise, if necessary, the IEP to make sure it is actually addressing your child's needs. So it's really important to understand these procedures to ensure that your child isn't unfairly disciplined for behavior that's related to their disability. One of the final pieces, and there's so much to the procedural safeguards, but one of the other big pieces of this document is the private school placement at public expense. Now, this is one that is not used often, but sometimes the public school is unable to provide a free and appropriate education for your child. And it may be possible to place your child in a private school and seek reimbursement from the school district. This is a really complex process that involves a lot of picture painting to demonstrate that the public school has failed to provide FAPE to your child and that this private school placement is necessary. Um, this is a big decision. Um, it's really important that you understand the legal requirements and the challenges. Okay. Um, this this particular component of the safeguards is often challenged really heavily um, for good reason. This is a really, really big decision. When it's challenged, the procedural safeguards have some outlines for that too. So the right to dispute resolution provides multiple avenues for resolving these disputes. So there's mediation, due process hearings, and filing complaints with the state education. Okay, each state has their own educational agency, and you can file a complaint to your state's educational agency. These processes are designed to address the disagreements in a very structured, uniform legal manner to ensure that your concerns are taken seriously. Mediation is voluntary, but it can really help both parties to reach an agreement with the help of a neutral mediator. I have attended meetings with a mediator, and I have loved every single experience that I've had. Sometimes, though, mediation just doesn't resolve the issue, and you can request a due process hearing. Some states you are required to have a lawyer. So make sure you are checking with your state's regulations um, about whether or not you need a bar certified lawyer. Understanding your procedural safeguards is just the first step. The next step is knowing how to use them effectively. When you find yourself in a challenging situation, it's really hard to stay calm, but it's crucial. We have to stay calm and document everything. I tell my clients all the time, if it's not in writing, it didn't happen. Okay? So we get everything in writing, we document everything, and that way we can use the safeguards to guide our actions. So here's a pretty common scenario that we see. Imagine you received a prior written notice indicating that your child's school wants to change their placement to a more restrictive environment, like a special education classroom rather than inclusion in the general education setting that they're currently in. You disagree because you feel like your child is doing really well and thriving in the general education environment with the right supports. So, the first thing we're going to do is we're going to review very thoroughly that prior written notice. What exactly is the school proposing? What are the reasons that they're proposing them? Are they based on a recent evaluation that was completed? Teacher observations, behavioral incidents? So, we're going to look at those and then we're going to gather our own documentation. So, this could look like reports from private therapists, feedback from your child's current teacher, or even um, a previous teacher, any other relevant information that you feel supports your position. Once we have all of our information, we are going to request a meeting so that we can collaborate with the team about the proposed changes. Okay, during that meeting, we are going to we're going to have a discussion. We are going to express our concerns. We are going to show our documentation. We want to paint a picture about what we see of our child and use the documentation as evidence of the picture that you have painted. We have to say things that people can see. We are also going to give the educational team time to respond and show us their evidence, their evaluation, their teacher observations, their behavioral incidents reports. Okay, so we're going to look at all of those and then decide as a team what would be the best placement. If the school still insists on the change and you still don't agree, remember we have our other components of the procedural safeguards. You might request an IEE, an independent educational evaluation, to get an unbiased second opinion of your child's needs. If that doesn't resolve the issue, then maybe mediation is another step. Okay. The goal is to find outside parties. If you and the school cannot agree, then we have to find third unbiased parties to help us see that middle ground and find a place where we can find the best education for your child. If mediation doesn't lead to agreement, then there is due process as a last resort. And some of these big steps are really daunting, but remember that most of the time they don't make it that far. Usually, the school and the parent, we can find a way to work together and agree. Each safeguard is there to protect your child's rights to a free and appropriate education. So, Some practical tips. Let's shift gears and talk about practical tips to help you navigate these safeguards most effectively. Guys, organization is key. Um, Having a binder or a digital system to track all of your documents. If you have a child who struggles with regulation and behavior at school, make sure you are keeping track, whether you're a digital person, a hard copy person, you're keeping track of all of the documentation sent home by your child's school, all of the emails, all of the records requests, everything. Okay, it's really important to paint this picture of your child when you're preparing for meetings. Questions. We have to ask questions when we don't understand things. It can be simple clarification questions. It can be, I don't know what that acronym means. We have to ask questions to make sure we are making informed decisions. Write them down. Write down questions you might have before a meeting and bring them with you. If you have questions at the meeting and need some time to think, or after and need time to think, write them down and email the team. That goes right along with documentation. If it's not in writing, it didn't happen. So we need to follow up with emails summarizing conversations that were had on the phone or conversations that were had at pickup. Okay. It needs to be documented. Another piece is building a collaborative relationship. It is really important to build that collaborative relationship with the school. I firmly believe that school admin and teachers don't go into this field for the fame and fortune. They go into it because they want what's best for kids. And maybe everybody's idea of what's best is different. And that's okay. It is important to remember that it's a partnership. You are an equal member in this partnership, and regular communication can really go a long way to forming that collaborative relationship. But sometimes you have to know when to seek help. Sometimes you're overwhelmed and unsure and maybe need to consider reaching out to an advocate or an attorney who specializes in special education law. Remember that in some states, if you're going to be filing for due process, you have to have a special education attorney um, who is certified to practice special education law. Okay, that was a lot of information. I really love the procedural safeguards. I hope that they helped you. I think we'll probably do more episodes in the future, diving a little bit more deeply into some of them. But thank you so much for joining me on this episode of Bridging the Gap. I hope you feel more empowered and equipped to navigate the special education system with confidence. Remember that using and understanding your procedural safeguards is critical to advocate for your neurospicy kiddos' needs. Before we go, a quick legal disclaimer. I am a special education advocate, not an attorney. The views and opinions expressed in this podcast are solely those of the host and guests and do not constitute legal or professional advice. If you have specific questions or concerns about your child's education, please see the transcripts for a link to schedule a complimentary consultation. Thanks for tuning in to this podcast of Bridging the Gap. If you found this conversation helpful, please subscribe to our podcast and leave a review. Join us next time as we continue to explore the latest insights and strategies in special education. Remember, together we can bridge the gap between families, schools, and communities to empower children